Okay. Okay. Hi. Welcome, everyone. Thank you for joining us here in person and everyone who's online. Before we begin, I'd like to acknowledge that we're gathered here today on Treaty 6 territory, a traditional gathering place for diverse Indigenous peoples, including the Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Ojibwe, Saulteaux, Anishinaabe, Inuit, and many others whose histories, languages, and cultures continue to influence our vibrant community. I'm just gonna, by way of introduction, my name is Aubrey Abaya. I am the Public Legal Education Coordinator here at the Center for Constitutional Studies. If you are not familiar with the Center, we are a public legal education and research hub housed here at the University of Alberta. Our commitment to public legal education is why we're so excited to bring you this particular session here today to help us better understand the Notwithstanding clause and its place in our charter today, especially given recent events, especially in Saskatchewan, just to be specific. So just the structure for today is going to be about 30 to 35 minutes of the talk, and we'll have 30 minutes for a Q&A after that. So if you have questions, we'll try to get to everyone's questions. And if you're online and you have questions, please post your questions in the chat. And we will hopefully get to all of them. I assume people have a lot of questions about this one. So our speaker today is Rob DeLuca, a researcher and lawyer who was born and raised here in Edmonton. He is also an alum of the Political Science Department here at the University of Alberta, as well as the University of Texas, Austin, and Stanford. He was formerly a program director at the Canadian Civil Liberties Association, where he worked on several Supreme Court interventions regarding the Charter. And he spent the last few years as a union side labor lawyer. So please join me in welcoming Rob DeLuca.
Thank you for the introduction. And I just want to start. I just first want to start by thanking the Center for Constitutional Studies and the Alberta Law Foundation for hosting the talk. I think it's an important topic, and I'm grateful for the invite. I'm also, grateful for the wide attendance and participation. The approach I'm going to take is, I think it's a sort of a varied audience, and it's a very large topic. So I'm basically going to take a broader kind of public legal education approach, to the subject. So specifically, just to give an overview of what I expect to present on. I'll just start with a brief overview of the clause, which I think most here are likely familiar if you're attending the talk, but I think it's just important to start there. And then I'll eventually turn to some of the traditional justifications for the clause. And after laying that basic groundwork, I'll then just turn to how those justifications have lived up to or not lived up to the actual practice of the clause. And here I just want to talk. I want to talk a little bit about how the practice of the clause has been very different, I think, in English-speaking Canada and French-speaking Canada, and eventually I'll spend a little time, I think, getting around to the argument that I think this disparate practice must be understood as related to the fact that Quebec has always had something of a complicated relationship with the Charter. So finally, in the process of addressing these disparate practices of the clause, I'll also argue that while the clause has raised some troubling legislative actions, it's ultimately still worth defending, which I think is becoming an increasingly controversial position. But before I get there, I do want to just say a few brief words about my background in the hopes it kind of illustrates what I hope to convey in the talk. So, as mentioned, I completed a PhD program in legal studies in the U.S., where nothing approximating the notwithstanding clause exists before practicing law in Canada. But I think the most relevant point is that, in addition to spending a decent amount of time practicing in the field of union side labor law, I spent about 4 years at the Canadian Civil Liberties Association. And so at CCLA, it was basically my job to advocate for charter rights and freedoms. And I think in brief, my day-to-day work really was to kind of try to use the charter as a shield for vulnerable rights and individuals against what we may have perceived as majoritarian excesses or whims, and against the significant power wielded by the state. I think that's very much at the core of what the charter is about. And I just want to sort of bring this to the fore because I still very much believe in this kind of work and in the role of the courts in enforcing these protections. And also just from a policy point of view, I also want to clarify, I'm not really here to justify some of the invocations of the clause to date. And it's just to be frank, in several cases, I think including the pending invocation in Saskatchewan, I think that the invocations have mostly been problematic. So with that said, and despite those points, my approach today will just be to try to take a wider perspective on the issue, and to give just a few arguments as to why I think the notwithstanding clause still has value, and including from a rights protected framework. So again, before we get there, I think it's just useful to begin by giving an overview of the notwithstanding clause and what it is and what it isn't. Sorry, I lost my. I didn't know where the clicker was for the. So while I think there is significant debate on how exactly the notwithstanding clause is supposed to work in practice, and I'm just kind of going to avoid that debate. I think it's clear that the clause makes some kind of exception to the Charter's ordinary protections, and so just to be clear, this exception is itself a part of the Charter. So the notwithstanding clause, I think, was very intentionally placed within the Charter itself at Section 33. So the result then is that the Charter itself provides for certain exceptions to some of the rights to some of the Charter's rights protecting provisions. And so just to move on to some of the text. So according to Section 33 sub 1, Parliament or provincial legislature may expressly declare that legislation or a part thereof shall operate, are the terms used, notwithstanding the protections found in sections 2 or sections 7 to 15 through 15 of the Charter. And then moving to the next clause, according to Section 33 sub 2, any legislation or provision subject to Section 33 declaration, quote, shall have such operation as it would have, but for the provision of this Charter referred to in the declaration. So, I mean, taken together, I take this to basically mean that a law protected by a proper Section 33 declaration will have legal force, despite the fact that it would ordinarily violate the Charter rights and freedoms referenced in the declaration. And again, there's, I think, some academic controversies about exactly what this means, whether a law is still valid or not, et cetera. But I really don't have time to go there, so I will just sort of move that aside. It may be a subject for the Q&A. But that said, and as noted, a Section 33 declaration can really only insulate legislation with respect to certain Charter rights and freedoms, and those are, of course, sections 2 and sections 7 through 15. And I won't go through those here again, it's time's limited, but just a brief overview gives a sense that this isn't exactly a small power being conferred to the legislative institutions. And so to simplify somewhat, this basically means that this basically also means that the remainder of the charter can't be limited by way of the notwithstanding clause. So most obviously, this means that a Section 33 declaration can't be used when the parent charter violation concerns certain democratic rights, mobility rights, and minority language rights. And then the remainder of Section 33 that isn't present here, subsections 3 through 5, then provide basically a 5-year expiry date on a declaration. And the declaration can also expire earlier if specified, and declarations can also be reenacted. And the choice of a 5-year expiry date is very much intentional. I mean, what it does is it ensures that any use of the charter beyond 5 years will need to be accomplished by a new parliament, i.e. it gives the public and political opposition an opportunity to make the invocation an election issue. And again, there's quite a few complications here, but I don't want to slow us down too much. I'll just pause to say that, you know, the Supreme Court has given some minimal guidance on how Section 33 is supposed to operate in practice. And specifically in Fort v. Quebec, the court effectively said that one thing, you cannot use the clause to retroactively protect legislation that has already been passed, as Quebec was in the habit of doing, and that a Section 33 declaration is sufficiently express if it simply refers to the section of the charter which contains the provision or provisions to be overridden. And so the result of the decision is that it's now basically routine to simply say that the legislation will operate notwithstanding all of sections 2 and 7 through 15, even if, you know, say one or two of those provisions might be applicable. And, you know, so just briefly, it's a very hands-off approach. And so that's just a bird's eye view of the clause. And to illustrate how the clause can operate in practice, I think it's helpful just to consider the current use of the clause that is now making national news. And so yesterday, as many of you will know, Saskatchewan Premier Scott Moe began the process of introducing legislation that would use the notwithstanding clause to protect a government policy that limits the rights of students under the age of 16 to choose their own names or pronouns at school without parental consent. And so the policy in issue is currently subject to an interim injunction by a lower court. And if the notwithstanding clause was not invoked, I think it'd be very hard to see how this kind of policy would survive charter review, and for several different reasons. But just very briefly, the policy severely curtails the privacy rights and freedom of expression rights of children by singling out students who may be exploring their gender identity. And it does it with, you know, an absolute bright line rule of 16 without, say, considering contextually the maturity of the student. However, that said, the relevant rights and freedoms are rights and freedoms that can be overridden, mostly be overridden by a Section 33 declaration. And just as an aside, I do think there is one possible exception here, and I'm sure, you know, it will be a point going forward, is that there is a charter protection for sexual equality at Section 28 of the charter, and the provision itself isn't straightforwardly subject to a Section 33 declaration. And so you can make the argument that in fact Section 28 prevents this kind of policy. But in any case, I think there's a very good argument that the clause, if invoked, will allow the Saskatchewan government to pursue the policy for the next 5 years, at which time the legislation at issue would need to be reenacted. So the basic problem I take to be is this: is that if you allow a provincial parliament to proceed with a rights infringing law, even if it is accepted that the considered judicial opinion is or would be that these limits on charter rights are unreasonable limits under Section 1, does that not defeat the very purpose of a charter? And so with that example and just the basic groundwork in mind, I want to now turn to some of the justifications for the clause that that were offered around the time the charter was introduced or shortly thereafter. And my reason for going back to this, I do want to make clear, I'm not going back to this because I'm an originalist. I'm not. But what I would say, however, is that, I think one of the reasons it's helpful, sort of to go back to the historical origins of the provision, is that I think we have, especially outside of Quebec, become effectively what I would say sort of constitutionalized by the charter. And by what I mean by that is that I think many Canadians increasingly identify with the rights and freedoms enshrined in the charter, as well as their judicial enforcement. And therefore, it becomes increasingly difficult to think of reasons as to why there were serious reservations about a judicially enforced charter, or why certain measures might be taken to make the charter a less demanding document. And at the outset, I also want to clarify that I don't think the introduction of the clause was a pure political power play. I think it's often raised in discussions, but I don't think that's accurate. So I think part of the historical context here is that the introduction of the Charter of Rights and Freedoms, with or without the clause, was a new and rather massive limitation on legislative power. The most important thing, of course, was that the charter was that it constitutionalized rights and freedoms, such that the rights and freedoms enshrined therein can only be changed by way of a constitutional amendment. So one way the clause was justified was that it was a way to preserve some measure of the traditional Canadian practice of parliamentary supremacy, where parliaments can have a final word on certain matters and for a certain period of time, but while simultaneously coupling it with the strong version of constitutional rights that are beyond democratic reach. But I think as a justification, this appeal to history mostly begs the question. So, I mean, rights are rights, and the adoption of the charter appears to be a statement that sometimes rights should be put beyond democratic interference. So to put it differently, why care about preserving a sphere of legislative supremacy if the issue is the rights and freedoms enshrined in the charter? So one substantive justification was the argument that the charter and its enforcement would never solely be about rights and freedoms. So in applying the charter, courts would inevitably be making decisions that would, at minimum, be intertwined with matters of social or public policy. And so in this context, the carve out for legislative supremacy was in part a response to this alleged problem. That is, the idea is that it would better allow legislatures to address issues of public policy if and when courts were strained into matters that are typically reserved for democratic institutions. So for instance, in 1993, former Premier Peter Lougheed, who is, of course, one of the chief supporters of the Notwithstanding clause, stated the issue thus. The then premiers of Manitoba and Saskatchewan and the premier of Alberta did not want to be in a position where public policy was being dictated or determined by non-elected people. We took the position that the Notwithstanding clause therefore definitely needed to apply to Section 2 of the Constitution under fundamental freedoms, insofar as the American experience had been that judicial interpretations and other actions which were fundamentally different from the view of legislators were taken from time to time. So, end quote. So in brief, the justification expressed here can be summarized as a concern that an unelected judiciary would be dictating major issues of public policy. An example that Lougheed himself raised is the issue of the right to strike. So whether and especially how one recognizes the right to strike has obvious and significant public policy implications. And some of the premiers took it as a good thing that democratic institutions would have the right to respond when such decisions issued from a court. So one of the reasons, I highlight this passage is I think it demonstrates how then Premier Lougheed and others were often very quick to cite the U.S. experience as justifying their concerns. And the leading example, which he may have had in mind, is what is basically known as the Lochner era of U.S. jurisprudence. And so for those who aren't familiar, basically in the early 20th century, for about 4 decades, U.S. constitutional politics was very largely defined by a U.S. Supreme Court that would routinely strike down legislation concerning commercial activity, such as basic workplace standards legislation. And so this included things like minimum wage laws, child labor laws, and similar. And the grounds on which they did so was that, in their opinion, any such legislation violated substantive due process rights, including, for instance, the right to contract. And the era specifically gets its name from a 1905 case, Lochner v. New York, and the issue there was basically a New York law that set maximum overtime working hours for bakeries in the state, in part because this wasn't really like Cobb's Bakery. These you try to think of industrial bakeries where where this health and safety issues are particularly acute, and they struck down the law on again on so-called right to contract grounds. So now just returning then to the Canadian case, just a related justification around this time that I think has become more central to how the Supreme Court of Canada has talked about the clause is the idea that the clause is intended to promote dialogue and accountability between the branches, including by allowing legislatures to disagree on what is required by the Constitution. So among other things, this means that judicial decisions can be reacted to by the legislature by passing a new legislation or by invoking Section 33 so as to replace the court's view of what the Constitution requires. And here the rule on expiry then ideally makes the public the ultimate arbiter of whether the legislature's invocation should continue. And an important adjunct, I think, of this argument is that because legislatures have a right to reply when legislation is found to be inconsistent with the charter, courts can be more frank in describing and protecting the rights involved, knowing that if a legislature believes the court has overstepped, the legislature has the right of final reply. And so just on this point, I want to emphasize, I think, a piece of the constitutional history that's important and is sometimes sort of passed over. And, as is well known, at the time of patriation, Canada already had a federal Bill of Rights in the form of legislation. And the Bill of Rights also had a notwithstanding clause, despite the fact, curiously, that Parliament could have conceivably repealed the Bill of Rights wholesale if it had wanted to do so. And the same was true for the several provincial bills of rights existing at the time. So the question then is, why include a notwithstanding clause in ordinary legislation? What's the point? In brief, the point of the notwithstanding clause was there to protect and promote the integrity of the Bill of Rights. What the clause, I think, was intended to do was to compel Parliament to expressly declare if and when it was acting notwithstanding protections in the Bill of Rights. And without the clause, the fear was basically that Parliament could simply depart from the Bill of Rights haphazardly or basically in secret. So just to add on to this basic argument, I think part of I think it was understood that the political difficulty in expressly departing from the Bill of Rights was in part to act as a deterrent to departures from the bill. So now the calculus obviously changes when legislatures can no longer simply, to put it a little over the top, rip up the document in question, but much of this justification can still be carried over to the idea of a notwithstanding clause in a charter. So in such cases, the justifications for the clause still operated under the assumption if and when a legislature invoked the clause, it would be expected to cause political difficulty for the party invoking it. And so just to give, I think a description that was given at the time, Alan Borovoy, the then executive director and general counsel of CCLA, I worked with Alan briefly. He really had a way with words and images. But at the time, he wrote an important editorial where he defended the clause, and this was taken up by supporters of the legislation, and his defense was basically that the invocation of the clause would always be a red flag. He called it. It'd be a red flag to the press and the political opposition. And I think what that idea captures is that as soon as the clause is invoked, it's basically a signal that something is a little, concerning, that we're one way to put it is we're suspending the charter, or however you want to frame it, that something serious is taking place, and that inevitably is a call to action. And I'll return to this point and how persuasive it is later, but before I get there, I think it's important to just cover a third major justification at the time. And this is the one that was offered by then Premier of Saskatchewan, Alan Blakeney, which is basically that a notwithstanding clause would allow the legislative and executive branches to advance so-called positive rights, and that a judicial monopoly on charter rights and freedoms would have the unfortunate effect of creating a hierarchy between the mostly negative rights enshrined in the charter and positive rights to which Canada and the province are and should be committed. And I think this view was sustained in part by Blakeney's view that the charter was largely inspired by an 18th century view and assumption that the only real dangerous source of power was the government, and not other private actors. And just to quote Blakeney, in an article he published a number of years later, quote, "Based upon historical precedent, a strong case can be made for the use of all three arms of government in protecting rights and freedoms. I think it is important that we formulate the problem as one of protecting the rights and freedoms of citizens. Some of those rights and freedoms are set out in the Charter of Rights and Freedoms. Some of the rights are set out in other documents, including declarations and covenants of the United Nations ratified by Canada, and some are part of our unwritten constitution. Among these rights, there's not a hierarchy of more important and less important, and it is inevitable that rights will come into conflict with one another. And so once one turns one's mind to the idea of positive rights, such as the right to housing or the right to healthcare, it becomes far clearer as to why the political or democratic branches would need to be at the center of the promotion and protection of rights. So an abstract right to housing or medical care means very little if there's no funding and no administrative apparatus of the state to administer it. So by and large, I think Blakeney's rationale for the notwithstanding clause is mostly faded from view, maybe not altogether, but to some extent, I think this disappearance arguably illustrates Mr. Blakeney's concerns that a focus on judicial institutions can have the effect of limiting the political imagination with respect to which rights we might reasonably seek to codify and enforce. So I now just want to turn, those again were given as just traditional justifications of the clause, but it's been quite a few years later. And so with these traditional justifications in mind, the question I want to ask is to look at how the clause has actually been used, or sometimes almost used in practice. And it depends a little on what you count as a use of the clause, but there's been about 20 uses of the clause since patriation, and with the majority or plurality of those occurring in Quebec. I think it's a majority there. And I do just want to bracket Quebec for the moment for reasons I'll expand on later. So as noted, part of the reason I do want to bracket Quebec is I don't think it's helpful to talk about the practice of the notwithstanding clause as kind of an undivided whole because of Quebec's very complicated standing in Confederation. So outside of Quebec, the invocations of the clause have, I think have rarely resulted in real legal consequences. So for instance, in 1986, Saskatchewan invoked the clause in back to work legislation after it had received an unfavorable court of appeal decision in a separate matter. And around the same time, Alberta was similarly threatening to use the clause for the same labor relations reasons. However, the use of the clause ultimately became unnecessary after the Supreme Court of Canada sided with the Saskatchewan government's position on the right to strike in the then labor trilogy. So Alberta itself has attempted to use the clause twice, but both times the invocation did not truly come into force. So in 1998, the Alberta government proposed legislation that would have capped compensation for forced sterilization in the province. And as I hope some are familiar, there is a very sad history of forced sterilizations in Alberta and elsewhere, including especially of Indigenous women in Alberta. And these sterilizations for a long time were done under the authority of Alberta's Eugenics Board, which had operated in the province as late as 1972. And when Alberta had introduced the legislation, the problem they were confronting is this very large problem of indeterminate legal liability for approximately 1,000 legal claims of potentially quite high damages. And part of the reason they knew this is because there had just been a case that the damages had resulted in approximately $1 million. But be that as may, as soon as the legislation was introduced, the government quickly realized that this was kind of a no-go territory, and it was withdrawn. So it never went into force. And then in 2000, Alberta also tried to use a provision to basically define marriage as only between a man and a woman. But this legislation was found to be ultra vires by the Supreme Court of Canada in 2004 in reference to same-sex marriage. So up until about 2018, 18 years later, it's then pretty quiet. And in 2018, and in response to a lower court decision, Saskatchewan then used the clause in a dispute concerning the funding of non-Catholic students attending Catholic schools. But again, this invocation was also made unnecessary when the Court of Appeals sided with the Saskatchewan government on appeal. So perhaps the critical recent development has been the repeated use of the clause by the Ford government in Ontario. So since 2018, there's been three separate uses, and I do want to cover the three. So in 2018, in the first use, the Ontario government had planned to use the clause in legislation that changed electoral boundaries of the city of Toronto, where I happened to article. So this was a little bit of a personal case to me. In the midst of a municipal election campaign, actually, yeah, I remember Ford when he was down there. But the government introduced the legislation in response to a lower court decision. In this case, they had an unfavorable and somewhat surprising decision. But eventually, the Ontario government received a stay from the Court of Appeal and withdrew the legislation. And eventually, the Court of Appeal on the merits reversed the lower court decision. And this decision itself was upheld by a 5-4 majority of the Supreme Court. So then in 2021, the Ontario government revisits the clause. And this time uses the clause to restrict the ability of private sector organizations. And I think very much unions were part of the mark here from running political advertisements outside of election periods. And the invocation was in response to a lower court finding that the legislation was unconstitutional. So despite the invocation of the notwithstanding clause, the Ontario Court of Appeal nevertheless struck down the legislation on other grounds. And in 2022, the Ontario government again used the notwithstanding clause, this time to impose a contract on education workers. And so despite the legislation, just shortly after it was invoked, the workers in question walked off the job, at which point the Ontario government applied to have the strike declared an illegal strike. And I mean, what's notable is that after significant public backlash, as well as threats of walkouts from other unions, the Ontario government relented and repealed the legislation. And they also, at the same time, withdrew the application asking to have the strike declared illegal. Now, given all this evidence, a number of commentators have argued that the recent increase in the use of the clause demonstrates that the clause is out of step with its purpose and should either be repealed via a constitutional amendment or should otherwise be significantly curtailed by the court via a revisiting of the court's relatively hands-off approach to Section 33 declarations. And I mean, personally, I'm not unsympathetic. I'm not unsympathetic to the concern, and I think so. I mean, I think part of the problem, just in the contemporary context that needs to be addressed, is that we do seem to be encountering an increased willingness, at least on the part of some governments, to use the clause in very early stages of constitutional disputes, and at least sometimes for very questionable motives, to the extent that can be divined. But all that said, I also don't think the evidence is it's not all on one side. And I want just to give a more personal example. So, I mean, you know, I was working by the time in 2018 when the municipal use was invoked. At that time, I was then working at the Canadian Civil Liberties Association. I'd moved on from the city. And I think one of the things that did strike me about that is that, I mean, to my mind, it wasn't close to one of the more important cases I had worked on. I think the organization does a lot of important work for charter rights and freedoms, and to me, it was a bit of a lesser issue. But I can't think of many cases that had as many people sort of contacting us, and not just contacting us. They were furious, they were engaged, they really wanted to vent. I would get voicemails, you know, this sort of thing when all this took place. And you know, I make this point because I do think that it's you know, I think sometimes there's a certain dismissiveness of the idea that invocations of the clause can really engage the public. But you know, my experience in this case is that, you know, that was very much true. You know, people were hot. They weren't going to let it go slide easily. And you know, a bit of the irony here is that it was eventually, you know, found to be effectively a legal thing to do without any need of the notwithstanding clause at all. So, you know, and just as a further example of this is, you know, it's now been invoked in Saskatchewan, but, you know, from my understanding is there was quite significant protests on the legislative grounds yesterday. And the reason I know that is I saw it in national news. And so I do think that is still very much a large part of the calculus in the notwithstanding clause. It hasn't lost, you know, that power to be, you know, as Alan put it, a red flag. So, and just on another issue, and it's again a little bit maybe closer to my own practice, is I do also want to just add a small note on freedom of association and the right to strike in particular, again with the Ontario case in mind. So part of the reason I think freedom of association and the right to strike has figured so prominently in this Section 33 invocations to date is because it's the kind of right that is also very much also a public policy issue. You know, a well-timed strike by a powerful union can substantially disrupt the workings of a city or province. And I think for that reason, it was very clear from the early days of the charter that there would be legislative pushback if the Supreme Court did recognize a right to strike. You know, it so happened that in 1987, the Supreme Court decided not to. But in 2015, of course, the Supreme Court changed its course on this and expressly found that the right to strike was an integral part of freedom of association. So given this historical context, I'd argue that the Ford's invocation of the clause in 2022 to, in an attempt to forestall a strike by education workers did more to advance the right to strike and freedom of association than if there had not been any invocation at all. And the reason I say this is, I mean, if you look at what actually happened, after the dust settled. So not only did the Ontario government lose the battle and repeal the legislation before, it had an opportunity to meaningfully go into force. Again, the application to have the strike declared illegal was also withdrawn. I mean, what also happened is that the entire dispute, I think, galvanized the public as well as unions from across the province. So, it was no longer simply the education workers. It was no longer GP. Other unions were there and being very vocal that this would be a much more general strike if the Ontario government went through with it. So my point here is that, just a short 7 years after the Supreme Court of Canada recognized the right to strike in the Charter, you had a very public organizing and very public deliberations that centered upon the importance of upholding the right to strike, as well as more wide-ranging discourse about the importance of unions and collective action more generally. And part of my point here is that the Charter and the rights and freedoms therein is not simply an abstract legal document. It doesn't simply speak for itself in the courts or otherwise. And I think that the example helps illustrate that often the substantive content of rights and freedoms and their exercise can be better defined and strengthened through this kind of political conflict and activity. And I sort of am purposely avoiding the language of dialogue because I do think there's something maybe a little deeper and a little more fractious going on here. And so just basically in sum, I would argue that this possibility has mostly come to fruition in English-speaking Canada. When the notwithstanding clause is invoked, it very often does enliven the public, the political press, and the political opposition. And further, I think the events in Ontario are at least suggestive of the fact that losing invocations may help to strengthen the exercise of these rights going forward. So with that, I want to conclude by turning to the difficult case of Quebec. Quebec has used the clause far more than any other province, usually relating to issues of freedom of expression, freedom of religion, and equality. And I won't have time to go through them all here, of course, but many of the uses have involved very public debates in Quebec and outside of Quebec. So for instance, in 2019, Quebec passed Bill 21, which is a bill that defines Quebec. Part of what it does is defines Quebec as a secular state, and which then prohibits the wearing of religious symbols, including certain religious clothing, such as the hijab, by public employees. And in this case, the case is still working its way through the courts, but a lower court has found that most of the legislation was saved by the notwithstanding clause, and that and other issues are now up on appeal, including the Section 28 issue that might arise in the Saskatchewan case. But in addition to this, there are admittedly, there's been several Quebec uses where the clause has been used despite no real clear court precedent being overturned by the legislature, and with little public fanfare. And what I have especially in mind here, there's 5 pieces of legislation that use Section 33 to protect pension plan legislation from a Section 15 based declaration of invalidity. And the basic issue here is that the pension plan legislation can be interpreted as favoring Catholic teachers over non-Catholic teachers. But these 2 kinds of examples, I think, raise 2 general points that are generally leveled against the notwithstanding clause. And first, if one does include the province of Quebec, and in some measure you have to, I've tried to avoid that. There is a lot more evidence that the clause has been used to act contrary to the Supreme Court of Canada's prevailing interpretation of the Charter. And second, if one includes the province of Quebec, it's also much more difficult to sustain the argument that there's always a political cost for using Section 33. So, I mean, Quebec, I think, if you look at the evidence, does it all the time, and it's often very popular when they do so. And so, for instance, Bill 21 is a relatively popular bill. There's no, grand concern about, the use of Section 33. I don't think in the public, as a matter of public opinion. And then there's also the cases where the use of Section 33 is mostly somewhat ignored in, for instance, in these pension plan cases. And so, I mean, while I think that these concerns have some weight and truth to them as far as they go, I would suggest that they mostly fail to account for Quebec's very complicated history in Canadian Confederation. So, I mean, obviously, one of the key points here is that Quebec was the only province not to sign on to the Charter, and among other things, their reasons for doing so included the belief that the Charter and several of its commitments did not adequately recognize Quebec's special place in Confederation. So my first point then is that we should not expect a Charter that is, often held out, especially in English Canada, as a great pan-Canadian instrument to apply with the same rigor and force in a province that expressly objected to its implementation. But I just also want to return to the operation and rhetoric surrounding the notwithstanding clause to make a deeper point, and that's that. So after Quebec did not sign on to the Charter, Premier René Lévesque famously passed legislation that added a standard notwithstanding clause to every law in force at the time, and this included retroactively amending every existing law. I mean, it was, I would describe it as sort of a legal middle finger to the rest of the country. And it is this practice, as well as Quebec's language laws, that eventually made its way up to the Supreme Court of Canada in Ford v. Quebec. And it's not that Quebec was per se opposed to a Bill of Rights, and indeed it had its own quite robust provincial Bill of Rights at the time. And what Quebec opposed was a charter signed on to without Quebec's consent and without adequately taking their own standing, what they believe is their own standing into consideration. And so just a flavor of this objection and how Section 33 was used to meet it, I think, can be helpfully found in the first comment on the notwithstanding clause that was made to the National Assembly by then Minister of Justice of Quebec, Marc-André Bedard. So quoting Bedard, by a general and systematic use of the derogatory clause, often called the Notwithstanding Clause. We are making sure that the National Assembly can keep its legislative powers intact within certain limitations without falling to subjection to an external legal frame. So sometimes I think this example is held up as to why the use of the Notwithstanding Clause has become normalized in Quebec in a way that it hasn't in other jurisdictions. And while I think that's true as far as it goes, I do want to just draw attention to an additional point, is that perhaps it's trite, but I do think that it's important that that Quebec's act of political protest self-consciously used and affirmed the charter in the very act of protesting. So, and this kind of wedding of the protest with the charter itself was made possible by the inclusion of Section 33. So on the one hand, Quebec protested that it would not subject itself to an external legal framework. And on the other hand, and because the Notwithstanding Clause was incorporated into the body of the charter, Quebec was at the same time adopting some measure of this legal framework, both in practice and in speech, the charter in the very act of protest. So in sum, I would suggest that one of the fundamental reasons that Section 33 still has value is that it has helped accommodate the gulf between Quebec and the rest of Canada, and that in the process has allowed the Canadian Charter to become increasingly adopted in Quebec, albeit in a somewhat convoluted fashion. So I'll end my prepared remarks there. I believe we've left time for Q&A.